The pre-sentence report and filing objections. The pre-sentence report, PSR, is a crucial document in the sentencing process. It is prepared by a probation officer and provides a detailed account of the defendant's background, offense conduct, and other relevant information. The PSR also includes a preliminary guidelines calculation, which forms the basis for the sentencing recommendation. The probation officer will summarize the indictment, stipulated factual basis, and, quite often, other investigatory reports in a section devoted to the summary of the offense. The probation officer will also interview the defendant shortly after adjudication in order to obtain vital demographic information about the person's family life, education, employment and family life for the court's consideration. Both the prosecution and defense have the opportunity to review the PSR and file objections to any factual inaccuracies or guidelines calculation errors. Timely and well-reasoned objections can significantly impact the final guidelines calculation and the sentencing outcome. Once a party files an objection, the probation officer will file an addendum to the pre-sentence report and either concur with the objection and adjust their calculation accordingly, or they will oppose the objection and provide a written basis for their position. Typically, any unresolved objections are addressed the morning of sentencing. Even if an objection is overruled, the basis for that objection could be useful in arguing for a downward variance on similar grounds. Preparing for the sentencing hearing. Adequate preparation for the sentencing hearing is essential for presenting the best possible arguments and evidence in favor of your client. Here are some key steps to effectively prepare for the sentencing hearing. 1. Prepare for the pre-sentence interview. It is imperative that the defense lawyer attend this meeting and the client not withhold anything back. This document will serve as a basis for the court's sentence and will follow the offender to the Bureau of Prison, as it helps determine what rehabilitative programming is available. Often, offenders are embarrassed to discuss physical or sexual abuse and want to deny any substance abuse. However, these stressors could open the door for some leniency at sentencing. 2. Review the pre-sentence report. Carefully review the PSR and identify any factual inaccuracies, guidelines calculation errors, or other issues that need to be addressed. 3. File objections. Submit well-reasoned objections to the PSR, addressing any issues identified during the review process. It's good to make note of any potential downward variances and departures in your objections if not noted in the report. Your attorney should cite specific guidelines, application notes and case law in support of the objection whenever sustaining the objection impacts the guideline calculation. 4. Gather mitigating evidence. Collect evidence that supports a downward departure or variance, such as letters of support, proof of rehabilitation efforts, or documentation of extraordinary family circumstances. 5. Prepare the defendant. Ensure that the defendant understands the sentencing process, the potential outcomes, and the importance of presenting themselves in a favorable light. Encourage the defendant to express remorse and accept responsibility for their actions. An offender's allocution is not the time to minimize their role in the offense conduct. 6. Review the annual and special reports from the Sentencing Commission. The USSC is a treasure trove of information that can help at sentencing. For example, they have reports documenting which crimes result in downward variances more often than others, which crimes or which type of defendant has a lower recidivist rate. 6. Court will appreciate a well-reasoned argument for a variance that is empirically supported by the sentences imposed throughout the country for similarly situated defendants. 7. Develop a sentencing memorandum. Prepare a comprehensive sentencing memorandum that outlines your arguments for a more lenient sentence, cites relevant case law, and presents the mitigating evidence. By following these steps, you can effectively advocate for your client at the sentencing hearing and increase the likelihood of a favorable outcome.